There are three courts of the European Union: European Court of Justice, the General Court, and the Court of Auditors. Firstly, we'll take a look at the composition of each court. The ECJ consists of judges, one from each member state, who are assisted by 11 advocate generals. The judges and advocate generals must be chosen from persons whose independence is beyond doubt and who possess the qualification required for appointment to the highest judicial offices in their respective countries. Secondly, the General Court. Article 254, Treaty on Functioning of European Union, sets out the relevant criteria. Both courts elect their own presidents. The term of office is a renewable 6 years. The treaty requires that judges are chosen by common accord of the governments of the member states after consultation with the panel. The Court of Auditors is composed of one auditor per member state, who shall be chosen from among persons who belong or have belonged in their respective states to external audit bodies or who are specially qualified for this office. The procedure of the ECJ generally consists of a written stage, a brief oral argument, presentation of the Advocate General's opinion, and then judgment by the court. This procedure relies heavily upon written documents, and oral argument is intended mainly to fill gaps or elaborate on specific points. The role of the Advocate General is to present a reasoned and exhaustive examination of the facts and the relevant case law and to give their opinion on how the case should be decided. This opinion will clearly have a great influence on the court, but it is not binding as perceived in the case of Facchini Dori versus Recreb, where the court refused to follow his opinion, proposing horizontal direct effect of directives. This opinion will clearly have a great influence on the court, but it is not binding as perceived in the case of Facchini Dori versus Recreb, where the court refused to follow his opinion, proposing horizontal direct effect of directives. The judgment of ECJ is a single collegiate judgment. There are no dissenting opinions. The jurisdiction of the court is divided between direct actions listed in Articles 263, 265, 268, 270 and 272 of the Treaty on Functioning of European Union, and preliminary references from the national courts mentioned in Article 267 of Treaty on Functioning of European Union. A brief summary of the key articles include Article 258 TFEU, which talks about actions by the Commission against member states in breach of their union law obligations. Article 260 TFEU refers to another action by the Commission if the member state fails to remedy the breach. The General Court was established in order to alleviate the caseload of the ECJ and was first known as a court of first instance. Treaty of Lisbon 2007 changed its name to General Court. It hears actions taken against the institutions of the European Union by individuals and member states, although certain matters are reserved for the European Court of Justice. Decisions of the General Court can be appealed to the Court of Justice, but only on a point of law. The Court of Auditors' main role is to audit EU revenue and expenditure, to check EU funds are correctly raised, spent, achieve value from money and accounted for, check any person or organization handling EU funds, including spot checks in EU institutions, especially the Commission, EU countries and country receiving EU aid, write up findings and recommendations in audit reports for the European Commission and national governments. It is also responsible to report suspected fraud, corruption or other illegal activity to the European Anti-Fraud Office. Furthermore, to produce an annual report for the European Parliament and Council of the EU, which the Parliament examines before deciding whether to approve the Commission's handling of the EU budget, and to give its expert opinion to EU policymakers on how EU finances could be better managed and made more accountable to citizens.